You served, you are serving, or someone you love is wearing the uniform right now. The path to U.S. citizenship through military service is real. It's faster than the standard path, and most people who qualify don't know exactly how to use it. You earned this. The system has rules. Knowing them is what gets you through it. In this video, you'll learn whether you qualify, whether you need a green card first, the 4 steps to apply, and the mistake most service members make. Can I get U.S. citizenship through military service? Yes. If you have served honorably in the U.S. Armed Forces, you can apply for citizenship through a faster process than the standard path. In this video, you get 4 chapters. Whether you qualify, whether you need a green card first, the 4 steps to apply, and the mistakes that delay or deny cases. I'm Giselle Rodriguez, immigration attorney and founder of the law offices of Giselle Rodriguez. With offices across the United States, hundreds of families have gone through this exact process, and I want to make sure that you have everything you need to do this right. I post new videos every day to keep you informed on everything immigration. If you're new to my channel, please consider subscribing so you never miss one. Before we continue, this video is general information. It is not legal advice. Every situation is different. If you are working on this, please speak to an immigration attorney about your specific case. Do I qualify for U.S. citizenship through the military? If you have served honorably in the U.S. Armed Forces and you meet the lawful status, service length, and good moral character standards, you qualify. The exact length of service depends on whether you served in peacetime or during a designated period of hostilities. There are 3 core eligibility requirements. First, qualifying service. You must have served honorably in the U.S. Armed Forces. This means the Army, Navy, Marine Corps, Air Force, Space Force, Coast Guard, or certain components of the National Guards and Reserves. A dishonorable discharge disqualifies you. Other discharge characterizations are reviewed case by case. Second, lawful status. You must have been lawfully admitted as a permanent resident at some point, or you must have served honorably in a designated period of hostilities. The hostilities pathway has been active since September 11, 2001, which means some current or recent service members may qualify without a green card first. Third, good moral character. USCIS reviews the past 5 years of conduct, with particular attention to anything during the service period itself. That includes criminal history and the accuracy of statements in the application. There are also age, English, civics test, and oath requirements. But for active duty members serving outside the U.S., some of these can be handled remotely or waived. So before anything else, identify your discharge characterization, your service dates, and your immigration status at the time of the service. Those 3 answers determine what pathway you qualify under. You enlisted right after getting your green card. You're 3 years into your service. Someone in your unit mentions that you can apply for citizenship now through your service. You had no idea. You thought that you had to wait the full 5 years like every other green card holder. You don't. Your service unlocked a pathway that cuts the residency timeline in half. Knowing the eligibility rules while you serve is the difference between waiting years and applying now. Do I need a green card to get citizenship through the military? Not always. If your service was during a designated period of hostilities, which has been continuously active since September 11, 2001, you may be able to apply for citizenship without a green card first. If your service was entirely in peacetime, you need a green card plus 1 year of honorable service. Past service counts. If you already served at least 1 year honorably and have a green card, you qualify now. No need to re-enlist. U.S. immigration law gives military members 2 separate pathways to citizenship, and the difference between them changes everything about who qualifies and how fast. The peacetime pathway applies to members who served honorably for at least 1 year. To use this path, you must already be a lawful permanent resident, and you must apply within 6 months of separation from the service or while still serving. The hostilities period pathway applies to some people who served honorably for any period of time during a designated period of hostilities. The key word is any. There is no minimum length of service. A single day of qualifying service can establish eligibility, and you do not need a green card first. In many cases under this provision, a lawful permanent resident card is not required before applying for U.S. citizenship. The current designation has been continuously in effect since September 11, 2001. Anyone who served honorably on active duty after that date served during a designated period of hostility, regardless of where they were deployed or what role they had. Same uniform, same service, two completely different pathways, depending on which set of rules applies. You served 2 years in active duty. You assumed you needed a green card before you could apply for citizenship. You didn't. Your service was during a designated period of hostilities. You met all the other qualifying requirements, September 11, 2001 to present, which means you qualify under the wartime pathway. No green card required, no 5-year wait. The path you thought you couldn't take was the one that was open to you the whole time. Knowing which pathway covers your service is the difference between being stuck and moving forward. How do I apply for citizenship through the military? 4 steps. File Form N400 and Form N426. Get the N426 certified by your military command, attend the biometrics appointment, and complete the interview and oath ceremony. The N426 is the verification of military service that distinguishes this application from a standard naturalization. Step 1. Submit Form N400 together with Form N426, the request for certification of military or naval service. The N426 is what tells USCIS that you're applying through the military pathway. Filing fees are waived for military applicants. Step 2. Get the N426 certified. If you are currently serving, this is a routine request. Bring it to your unit's personnel office, sometimes called S1 or J1, depending on your branch. They process these for service members regularly. Do not bring it directly to your commanding officer unless personnel tells you to do so. If you are no longer in service, the certification usually comes from the National Personnel Records Center in St. Louis. Request it through them and allow several weeks. Start this step before you file the N400. Not after. Without certification, USCIS cannot verify your service, and the application stalls. Step 3, attend the biometrics appointment for fingerprint, photo, and signature. For active duty members serving outside the U.S., biometrics can sometimes be done at a U.S. military installation overseas. Step 4, complete the interview, the English and civics tests if required, and take the oath of allegiance at the ceremony. Once you take the oath, you are a U.S. citizen and your certificate is issued. Skip the N426 and the case stalls. The total process from filing to oath typically runs 6 to 12 months for military applicants, significantly faster than standard naturalization. And unlike family or employment-based green cards, the military pathway has no per-country wait times. The timeline is the same regardless of where you were born. You filed your N400 last year, you waited, nothing moved, you called USCIS, and finally found out that they never received the Form N426. You filed the N400 alone and assumed your service records would be auto-attached. They don't. The N426 is on you. You walk it through your command, get it signed and certified, and submit it to USCIS. 4 months later, you're at your interview. Knowing the N426 is a separate filing is what keeps your case moving instead of sitting in a queue. What mistakes do veterans make when applying for citizenship? 3 things. People assume that any military service qualifies, no matter what the discharge says. People miss the military service verification step, and people apply under the wrong pathway. Each one delays the case by months or denies it entirely. First, assuming any military service qualifies. Honorable service is the standard. Honorable qualifies, dishonorable disqualifies. The categories in between, general under honorable conditions, other than honorable, bad conduct, are reviewed individually and create real risk to the application. Pull your DD-214 before you file. If the characterization is anything other than honorable, talk to an attorney before you submit. Second, missing the military service verification. This is the single most common reason military citizenship cases stall. People file the citizenship application thinking USCIS will pull their service records automatically. USCIS does not. The verification form is the applicant's responsibility. Get it certified by your command and submit it together with your application. If you served years ago and are no longer in the military, the certification comes from the National Personnel Records Center in St. Louis. Request it from them well before you file. Third, applying under the wrong pathway. Service members sometimes assume they need to wait the full 5 years for permanent residency before applying, when their wartime service actually qualifies them right now. Others assume their peacetime service qualifies under the wartime pathway when it doesn't. Filing under the wrong pathway creates a denial that costs months to fix. The pattern across all three is the same. People move forward without confirming the discharge, the verification, or the pathway. Slow down at the start, and the application process is faster than almost any other immigration path. You separated from the service 2 years ago. You assumed your honorable discharge meant you qualified automatically. You filed the N-400. The application came back denied. The discharge was actually general under honorable conditions, not honorable. Different category, different rules. You had to file an upgrade request with the Military Records Board before you could refile. 2 years of waiting because nobody told you that you had to look at the exact characterization on the DD-214 before filing. The discharge characterization is the first thing to check. If you served, you earned this pathway. The system is faster than the standard naturalization because the country recognized that service matters. Knowing the rules, the right pathway, and the steps to file is what turns an earned right into a finished application. If you are starting this, pull your DD-212. Identify your discharge, characterization, and service dates, and confirm which pathway covers your service. If your situation involves a non-honorable discharge, prior immigration history, criminal history, or a denied application, please speak with an attorney before you file. An attorney's job here is to tell you honestly what your real options are before you take a step that makes things worse. There are also pathways for family members of service members, including parole in place for spouses, parents, and children, and citizenship for surviving spouses. Those topics get their own video on the channel. If you want help walking through your specific situation, call our office or visit our website. The information is in the description. Book a consultation and we will tell you exactly where you stand. I'm attorney Giselle Rodriguez. You've got this.